Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. Today we're going to talk about so-called dual intent visas, mostly because I just feel like doing it. It's kind of an interesting topic to me. I'm sure it's incredibly boring to anybody who's not been around U.S. immigration matters over the years. But to me, dual intent visas are rather interesting because they sort of straddle a line, oftentimes, between non-immigrant visas and immigrant visas. What are we talking about with respect to dual intent visas? Well, first of all, what are we talking about with respect to dual intent? In previous videos on this channel, we've discussed things like Section 214B of the Immigration Nationality Act and the analysis that consular officers have to undertake when analyzing a visa application, and specific to undertaking an analysis where they try to decide, is the individual applying for this visa, do they have strong ties to their home country and weak ties to the United States? Basically, what they're trying to ascertain is whether or not the individual in question is a threat of just remaining in the United States after they get there on a non-immigrant visa. Because a non-immigrant visa is, by definition, non-immigrant. It is specifically meant for those who do not have what is called immigrant intent. If it is determined there is some level of immigrant intent involved or inherent to an individual applying for a non-immigrant visa, there's a very, very high probability that that individual is going to be denied for that visa. Cut to the other side of the equation, immigrant intent. One files for something like a CR1 or an IR1. That's the spouse of a United States citizen who's looking to move to the United States to simply live there. Again, someone in, say, quote-unquote, green card status in the United States. That individual, that immigrant intent, you have to show that and it's not so much an affirmative burden of proof, but one has to have the true intention of moving to the United States with the intention of residing therein. That needs to, the intended place of residence needs to be the United States of America. This is a little bit, so again, we've got two competing things here, two different sort of intentions going on. Dual intent visas straddle this line, okay? A K-1 visa is a very good example of a dual intent visa, albeit it's a little bit more straightforward than some of the other ones. And I'll go into some of the other ones toward the end of this video. The K-1, we more often deal with family-based immigration out of our office, so the K-1 is something not only I'm rather intimately familiar with, but also something we deal with more frequently than, say, certain employment-based visas that have dual intent. But the same analogies tend to apply. With respect to a K-1, it's a 90-day non-immigrant visa, but if the individual in question fulfills certain requirements, i.e. marriage to their American citizen counterpart and filing for what's called adjustment of status to lawful permanent residence in the United States, so long as those requirements are fulfilled, those prerequisites, if you will, are fulfilled, the individual in question can go ahead and adjust status over into green card status. Now, the difference between this type of visa and maybe some of the employment-based ones is the K-1 is, for all intents and purposes, really treated like an immigrant visa. It's treated, in fact, very much almost identically to an immigrant visa, as opposed to, say, the O1 visa or the L1 visa, H-1B visas to some extent. These type of visas allow for dual intent. So they're strictly speaking non-immigrant visas, but if certain requirements, notably enough period of time has gone by that one has maintained that status in the United States, one could make the application for a change of status over to green card status. And that's perfectly acceptable. And having those two intentions in one's brain at the time one applies for one of those visas is not in and of itself going to result in a denial based on something akin to or exactly is Section 214B of the Immigration Nationality Act. One can have the intention on, say, something like an O1 visa that, yeah, maybe one day, let's say I'm an actress going to the United States or an actor going to the United States. I meet the O1 requirements for exceptional ability, and I'm going to go to the United States in O1 status. But I do, in the back of my mind, yeah, it might not be, I might want to fully live in the USA and maybe get a green card one day, maybe even naturalize to U.S. citizenship. these are perfectly acceptable intentions to have with respect to a dual intent visa. Again, depending on the type of dual intent does not apply to every visa category. So I strongly recommend that one not just take this video and think of it as the end-all be-all on the issue of intentions with respect to visa. Hiring or retaining the services of a legal professional, immigration professional, with whom one is most comfortable and with whom is going to be the most conveniently placed for an individual is the best thing to do with respect to these issues. But it is something kind of interesting to think about, that there are sort of one type of visa, another type of visa, non-immigrant, immigrant, and then there's these kind of hybrid type of visas that are in the middle.